Hi there, this is Jonathan Ginsberg. I'd like to talk to you today about your Section 341 hearing in your Chapter 13 case. As you probably know, every bankruptcy case, either Chapter 7 or Chapter 13 or Chapter 11 for that matter, requires you as the debtor to attend something called a first meeting of creditors. This is also called a Section 341 meeting or a 341 hearing. The reason it's called that is because Section 341 of the Bankruptcy Code says that every debtor who files bankruptcy must appear to be examined by the trustee regarding the petition and to answering questions the trustee might have. So these hearings are mandatory. They're actually very, very brief. And in Chapter 13, you'll see the place and date and time on your notice of filing and notice of hearings. And typically the 341 hearing is held in a small courtroom. It's not in front of a judge. I think people get confused by that. There's no judge there. It's just in front of a trustee, the Chapter 13 trustee. Typically it's one of the attorneys that works for the Chapter 13 trustee. So it's pretty informal. It's around a big table. They do tape record these things, but this is not like a formal court hearing that you might have had if you've ever been to state court or superior court. This is not like that at all. This is a hearing. You are under oath, but there's no bailiff. There's no there's no formalities of a regular courtroom, and there's no judge. And basically what happens in a 341 hearing in Chapter 13, it's going to be about a 5 to 7 minute ordeal. And the trustee is going to ask you a series of questions. And every trustee's got a few different questions, but for the most part, they're going to ask you to state your name and address. They're going to ask you to produce 2 forms of ID. And you should be aware of this certainly ahead of time, but you want to have a picture ID, like a driver's license, and a second form of ID that has your full Social Security number on it. It shouldn't be XXX, 1, 2, 3, 4. It's got to be the full social. That should be either a Social Security card or it should be a health insurance card. That'll do. Driver's licenses don't have a full social. Passports don't have a full social, so don't just bring those. You really want to look and make sure you've got your full social and some sort of a government-issued or health insurance company-issued document before you come. So the trustee will verify that your name is what's shown on your identification card. And by the way, this is just as an aside, I always look at my clients' driver's license and if they've got a Social Security card to make sure that the name on their petition is the same as what's on their ID. Because if not, the trustee is going to ask me to amend the petition and to basically show that there is an alternate name, AKA, formerly known as, whatever it may be. And you want to make sure that the names that are showing up on your petition are the same ones on your ID. So after that's out of the way, the trustee will ask you if the tax return that he has in his hand, because again that's been submitted ahead of time, is this tax return accurate? Have you made any changes to it? And of course you probably would say no because there have not been. The trustee will then give you back your tax return for the last year. Then the trustee will ask you a series of questions, and I've got the questions here linked here, but basically just some basic questions. Is everything about you're going to tell me true and correct? Have you bought or sold any property within the last year? Have you transferred any property to anybody? Have you been a defendant or a plaintiff in any kind of lawsuit? That sort of thing. Do you expect anybody, has anybody left you any money, or do you expect to be left any money? They're looking for assets for the estate, that sort of thing. A trustee will ask you about secured debt. Or do you want to keep your house, your car, that sort of thing. They may ask you if you have insurance on it, may ask you about tax debt, may ask you about your employment. There's just a variety of things. It's usually 15 or 20 questions. And again, we always prepare for those ahead of time, and I'll give you a list of them if I've got them for that particular trustee. And then creditors can ask questions, because again, this is a meeting of creditors. Normally, creditors don't even show up. It's very rare that you even have a creditor show up, but if somebody did, they might ask about insurance, they might ask about your intention, that sort of thing. Maybe they'll ask what caused you to have to file bankruptcy. But it's usually pretty brief. And then at the end of the 341 hearing, the trustee will generally announce verbally objections that he or she has right now. So sometimes there'll be more objections in writing, but they'll maybe announce there's problems with funding, not enough money has reached the trustee's office, maybe there's a term problem, maybe there is a missing creditor, maybe there's some change in employment, any number of things. It could be just something on the paperwork that, you know, middle initial was left out or something like that. And typically the trustee will announce 5 or 6 objections. Almost every case has objections, so I want you to not be too concerned that there are objections in your case. There are almost always going to be objections. That's our job to fix them. But basically, that's what happens at the 341 hearing. Afterwards, I will usually stand outside with you, go to a private little room, if there's one available, and go through the different objections, and let's figure out how we solve them. Typically, we have 4 to 6 weeks to get them fixed. That's before the confirmation. The purpose of the objections that the trustee has said, these are impediments, barriers to confirmation, and we normally have, again, about a month or longer to get them fixed. It's obviously to your interest, your best interest, to get these things fixed as quickly as possible. I tell my clients, come to my office or call me within the next couple of days. Let's get these objections fixed, and at that point we'll be ready for confirmation. So that's what happens at a 341 hearing. Again, no judge. It's fairly informal. It's going to last about 5 to 7 minutes. And the most important thing to remember is nothing final happens at the 341 hearing. Even the objection will say, comes now the trustee and asks this court to dismiss the case for the following reasons, does not mean the case is dismissed. It simply means the trustee has identified objections. We got to fix them now. So that's what the 341 hearing is about in Chapter 13. Nothing to be too worried about. In fact, I even would tell you, come early and watch 2 or 3 of them before yours, and that way you can see the questions that are being asked. I tell my clients, you know, come a half hour early, watch 7 or 8 of them, and then pull me outside if you have any questions, so we can go through how to best answer those things, answer those questions, and prepare yourself for your 341 hearing. So that's what it's about in Chapter 13. Hope this has been helpful, and we'll see you soon.